The Justice Department says the January 6th compensation fund is dead. But when Todd Blanche was asked whether January 6th defendants could still receive taxpayer money through another legal route, he would not rule it out. That distinction matters because killing one named fund does not necessarily prevent settlements from being paid through existing government procedures. And the evidence here forces us to separate two very different claims: what the Justice Department has actually promised and what critics fear it may eventually do. Start with the exchange itself, because this is where the strongest evidence is. Blanche was repeatedly asked about the so-called anti-weaponization fund, a proposal associated with compensating people who claimed they were unfairly targeted by the Justice Department. On that point, his answer was unusually clear. There is no fund, no money was transferred into it, no commissioners were established, the fund is dead, and according to Blanche, it will remain dead. Then the question changed. Instead of asking whether that specific fund would return, Kristen Welker asked something much narrower and much harder to evade. Could Blanche guarantee that someone involved in attacking the Capitol on January 6th would never receive taxpayer money through a claim against the federal government? Blanche did not give that guarantee. His explanation was legal and procedural. Anyone can file a claim against the federal government. He said he would not predict on television whether hypothetical litigation might eventually result in money being paid. That is not by itself an admission that the Justice Department intends to compensate January 6 defendants. It would be irresponsible to present it that way, but it does expose the limitation of the administration's public assurance. The promise concerns one particular fund. It does not appear from this exchange to be a categorical promise that no compensation could ever be paid through another mechanism, and that is our first real finding. The fund can be dead while the broader possibility of government payments remains alive. Those are not contradictory statements legally. Politically, however, the distinction is enormous. The procedure being discussed is the Federal Tort Claims Act. In basic terms, it provides a process through which people who believe they were injured by wrongful conduct of the federal government can pursue certain claims. A claimant does not simply announce a number and receive a treasury check. There is an administrative process first, followed, depending on what happens, by potential litigation. That procedural detail matters because it destroys the simplest version of this story from both directions. Critics cannot honestly say Blanche admitted that January 6th defendants are definitely getting paid. He did not. But the administration also cannot use the death of one specially named compensation fund as proof that every potential avenue for payment has disappeared. Blanche's own answer leaves litigation and the ordinary claims process as separate questions. Now consider why critics are suspicious. The source points to the Justice Department's settlement with the family of Ashley Babbitt as the precedent that changes the political meaning of Blanche's refusal. Babbitt was shot by a Capitol police officer during the January 6th attack while attempting to climb through a broken doorway near the House chamber. The Justice Department later reached a $5 million settlement with her family. Whatever your politics, that settlement changes the context. Once the government has already settled one prominent January 6th related lawsuit, it is no longer purely theoretical to ask whether other claims could end with taxpayer-funded settlements. The existence of a settlement does not prove that future cases will be handled the same way. Each case has its own facts, claims, and defenses, but it makes Welker's question concrete rather than hypothetical political theater. So apply a consistency test. If an administration controlled by the opposite party had pardoned people convicted of assaulting police during a political riot, then its Justice Department later refused to guarantee that those same people would never receive settlements from taxpayers. Would you accept the special fund is dead as a complete answer? That is the standard worth debating, because the political identity should not change what evidence we demand. There is another contradiction in Blanche's interview, and this one is even easier to see. He insisted that the Justice Department will prosecute people who assault law enforcement to the fullest extent of the law. Welker then confronted him with President Trump's January 6th pardons, including pardons for people who had pleaded guilty to assaulting police officers. Blanche's answer was that these are separate constitutional questions. A prosecutor can prosecute someone. A president can later pardon that person. Constitutionally, those propositions can coexist. Blanche is correct that presidential pardon authority and prosecutorial authority are different powers. But legal compatibility does not eliminate the political contradiction. the administration is simultaneously asking police officers to believe that assaulting them will bring the strongest possible prosecution while defending presidential pardons that erased punishment for people convicted in connection with assaults on officers during January 6th. When Welker pressed that contradiction, Blanche did not condemn the pardons. Instead, he defended the president's constitutional authority and pointed to pardons issued under President Biden. Again, notice what happened. The answer moved from the underlying standard, what should happen when someone assaults police, to the existence of presidential power. Those are different questions. A president may possess the legal authority to do something without that decision automatically becoming consistent with every principle his administration publicly claims to defend. The president had the power answers the constitutional question. It does not answer the credibility question. And this distinction is one of the easiest things to lose in political coverage. Something can be lawful and still contradict the standard used to justify an administration's broader agenda. At what point should voters stop asking only whether a president possesses a power and start asking whether the way that power is used matches the principles the administration demands everyone else respect? That question takes us to the deeper issue in this story, not the existence of lawsuits, but who will defend the government when those lawsuits arrive. The source material describes claims being pursued on behalf of large numbers of January 6th participants. One attorney discussed there is Mark McCloskey, who is said to represent roughly 700 claimants. Other lawyers are described as representing additional January 6th figures, including people associated with groups such as the Proud Boys and Oath Keepers. Those claims are not judgments. Filing a lawsuit does not establish that the claimant was wronged. Asking for hundreds of millions of dollars does not mean hundreds of millions will be awarded. And political sympathy from an administration does not automatically establish collusion. That distinction has to remain clear. But critics are focused on something more subtle. What happens when the institution responsible for defending the federal government may be politically sympathetic to the people suing it? Normally, litigation is adversarial. One side makes a claim, the other side challenges it. Evidence is tested, legal arguments collide. A judge may ultimately decide what survives, or the parties may negotiate a settlement based on the risks each side faces. But imagine what happens if the defendant does not really want to fight. The existence of a courtroom does not automatically guarantee meaningful adversarial testing. A government defendant can choose litigation strategies, decide which arguments to emphasize, determine whether to pursue particular defenses, and, within legal constraints, decide whether settlement makes sense. That is why the question is larger than whether January 6th claimants have a right to sue. Of course, people can pursue legal remedies available to them. The important accountability question is whether the Justice Department will defend those cases using the same institutional standard it would apply to politically disfavored claimants. Right now, the material does not establish that the department has secretly decided to surrender future January 6th cases. That remains an allegation and prediction made by critics. But Blanche was handed an opportunity to draw a bright line. He could have said that claims would be evaluated rigorously, that the government would defend itself independently, and that political favoritism would play no role. Instead, in the exchange presented here, he emphasized the existence of the legal process and refused to predict outcomes. That answer may be professionally cautious. It is also politically incomplete. And this is exactly how a reasonable viewer can get trapped by political packaging. The fund is dead is a real statement, but it answers a narrower question than the one many people think it answers. Repeat the broader conclusion without checking that distinction, and someone else gets the political advantage while your credibility carries the risk. Don't get played. The evidence discipline for American politics is a ready-to-use system for catching precisely that gap before you react. It works on the next clip, filing, poll, or statistic too. The complete digital ebook is only $9 one time. Open the description and click the first link now. The same link is in the first pinned comment. Because the settlement history makes the next question much harder. Look again at the Babbitt settlement. The important point is not whether you personally believe that settlement was justified. We do not have the full evidentiary record of that case in this source, so pretending to adjudicate it here would be irresponsible. The important point is institutional The Justice Department had a January 6th related claim against the government in front of it, and the matter ended in a multi-million-dollar settlement. That means future concerns about settlement strategy cannot simply be dismissed on the ground that government compensation is unimaginable. But one precedent still does not establish a conspiracy. This is where the strongest argument against the critics deserves to be taken seriously. The Justice Department settles cases all the time. Settlement does not necessarily mean the government believes a claimant was morally right, politically sympathetic, or legally certain to win. Governments settle because litigation carries costs and uncertainty. Attorneys evaluate evidence, procedural risk, potential damages, and the consequences of losing. Blanche also has a legitimate reason not to promise the outcome of litigation that may not even have been filed yet. An attorney general announcing in advance that an entire class of claimants can never receive a settlement, regardless of facts, could itself raise concerns about prejudging cases. That is the strongest defense, and it matters, but it still leaves a testable standard. Will these claims receive the same scrutiny that comparable claims would receive from a Justice Department whose political leadership did not sympathize with January 6 defendants? That is what should be watched, not a viral clip, not a facial expression, not speculation about what Blanche really meant. Watch the pleadings, watch the government's responses, watch whether motions are contested, watch settlement agreements, watch the factual findings courts make, watch whether career lawyers defend the government's position or whether unusual decisions are imposed from political leadership. That evidence would move this story from suspicion toward proof or toward exoneration of the suspicion, and that is a much stronger position than pretending we already know the ending. The source introduces another dispute involving Trump, the Justice Department, and the IRS, arguing that it demonstrates a broader concern about adversarial government litigation. It describes litigation challenging an agreement allegedly providing Trump, members of his family, and related business interests protection concerning tax matters. Critics characterize that arrangement as improper and say federal employees could effectively be forced to participate in conduct they believe violates the law. Those are serious allegations. They are also allegations being litigated, not conclusions we should declare established merely because one side states them forcefully. The significance for our investigation is narrower. Critics see a pattern in which political control of the executive branch creates unusual situations where the administration may influence both sides of a dispute. Trump or his allies benefit from an outcome, while agencies controlled by the same administration are responsible for defending the government's opposing institutional interests. That structural problem is real enough to examine even before deciding whether any specific agreement is unlawful. The presidency controls the executive branch. The Justice Department is part of that branch. The IRS is part of that branch. When litigation directly affects the president or politically favored constituencies, the public, therefore, has a legitimate interest in whether normal professional independence survives. The source says judges have already confronted related questions about whether disputes remain genuinely adversarial when government parties no longer contest an outcome. But be careful with the leap critics want to make. A concern about compromised incentives is not proof that every future settlement is corrupt. A president appointing officials is not proof those officials will violate their duties. A politically convenient settlement is not automatically an unlawful settlement. To establish something stronger, you need evidence of what government lawyers were instructed to do, what defenses were available, why those defenses were abandoned, how settlement values were calculated, whether normal review procedures were followed, and whether comparable cases received comparable treatment. That is the evidentiary threshold. And it gives us a better way to understand Blanche's Sunday interview. His refusal to guarantee zero payments does not prove a secret compensation program. What it proves is that the death of the Anti-Weaponization Fund does not settle the broader issue. That may sound like a small distinction. It is not. Political messaging frequently works by answering the easiest version of a question and allowing audiences to assume the difficult version has also been answered. Is there a special fund? No. Was money transferred into that fund? No. Will that fund be revived? According to Blanche, no. Can January 6th claimants nevertheless receive government money through ordinary litigation or settlements? No categorical guarantee was given. Those four answers can coexist, and once you put them beside each other, the story becomes clearer. The administration's strongest defensible claim is narrower than its supporters may want it to be. The critics' strongest defensible claim is also narrower than some critics are presenting it. We know the fund was described as dead. We know Blanche refused to predict or categorically prohibit payments arising from litigation. We know January 6th related claims exist. We know at least one prominent January 6th related lawsuit involving Babbitt's family ended in a $5 million settlement according to the material. What we do not know from this evidence is whether the Justice Department has already made a secret decision to pay hundreds of millions of dollars to other January 6th claimants. That claim goes beyond what has been established, and preserving that boundary actually makes the legitimate concern harder to dismiss, because you do not need a secret memo proving a predetermined payout scheme to demand oversight. You only need a foreseeable conflict and enough institutional power to make the outcome worth watching. Consider the incentive structure. Trump publicly expressed sympathy for people prosecuted over January 6th and issued sweeping pardons. His administration's Justice Department is now responsible for handling claims brought by some of the same political constituency. That does not automatically dictate the result, but it does create a reason for transparency. The public should be able to determine why settlements are reached, what legal exposure justified them, whether career lawyers agreed with those decisions, and whether the same standards would apply to people on the other side of the political divide. That last test matters most. Suppose hundreds of protesters associated with a movement Trump strongly opposed sued his Justice Department for enormous sums, claiming previous federal law enforcement actions had wronged them. Would his supporters accept settlements without demanding to see the government's defenses? Would they accept an attorney general saying that anyone has a right to sue and that he cannot discuss hypothetical outcomes? Maybe, but I suspect many would demand aggressive scrutiny before taxpayer money moved. That is not an argument for denying January 6th claimants their legal rights. It is an argument for applying the same evidentiary and institutional standard regardless of who benefits. And the same principle works in reverse. Critics of Trump cannot fairly declare every settlement corrupt simply because they dislike the claimants. If evidence eventually demonstrates genuine government wrongdoing against a particular person, that person does not lose access to legal remedies because his politics are offensive or because his conduct elsewhere deserves condemnation. That is what rule-based accountability requires. So what evidence should change your mind? If government filings show career attorneys vigorously evaluating these claims, asserting appropriate defenses, documenting legitimate reasons for settlements, and treating comparable cases consistently, then the theory of a predetermined political payout becomes much weaker. If instead, records show strong defenses being abandoned without explanation, unusual political intervention, dramatically favorable settlements unsupported by ordinary case evaluation, or internal objections being overridden, the concern becomes much stronger. That is the difference between investigation and prediction. One asks what the record demonstrates, the other announces the ending before the documents arrive. There is also a human dimension that political arguments can obscure. January 6th involved police officers defending the Capitol under extraordinary conditions. Blanche's Justice Department now says people who assault law enforcement will face maximum prosecution. For officers who were assaulted that day, presidential pardons followed by potential compensation claims from participants inevitably create a difficult question about what the government's promise to protect law enforcement means in practice. Again, pardons and prosecutions are legally distinct. But institutions are judged not only by whether each individual action fits inside a constitutional box, they are judged by whether their actions form a coherent standard. If assaulting an officer demands maximum accountability today, voters are entitled to ask why assault convictions arising from January 6 were treated differently at the presidential level. Blanche's answer is presidential pardon power. That explains how it happened. It does not explain why the underlying principle should feel consistent to the officers affected. And this is where political rhetoric often performs another substitution. A question about judgment becomes a question about authority. Was this consistent with your stated principle? The president had the authority. Those are not interchangeable. A president has broad authority to pardon. That does not make every pardon wise. A Justice Department has authority to settle litigation. That does not make every settlement impartial. A claimant has the right to seek redress. That does not mean every claim is meritorious. Once you separate authority from judgment, the entire controversy becomes easier to evaluate. The administration should be judged on what it actually does with the cases, not on what critics predict it will do. But critics are justified in refusing to treat the phrase "the fund is dead" as the final answer, because the interview itself establishes that the named fund and the broader litigation process are different things. That is the contradiction we started with, and now we can answer the central question. Did Blanche reveal that the Justice Department definitely plans to secretly pay January 6th defendants through another route? No. The evidence presented here does not establish that. Did he close the door on taxpayer-funded settlements arising from their claims? Also no. He explicitly declined to guarantee the outcome of potential litigation and pointed instead to the ordinary process available to people claiming injury by the federal government. The next stage of the story, therefore, will not be decided by another television interview. It will be decided in case files, complaints, government responses, motions, settlement documents, judicial orders. And if they become available, records explaining why the Justice Department chose to fight one case and resolve another. That is where claims of political favoritism can actually be tested. The institutional responsibility sits with the Justice Department leadership because it controls the federal government's litigation position. The political responsibility ultimately reaches the administration because Trump has publicly aligned himself with January 6th defendants and exercised presidential power on their behalf through pardons. But responsibility to demonstrate fairness does not equal proof of misconduct. That line matters. In fact, keeping that line intact is what allows legitimate criticism to survive contact with opposing evidence. The strongest conclusion available today is not that a hidden payout scheme has been proven. It is that the administration's declaration that one compensation fund is dead does not resolve the separate question of whether January 6th claimants could receive money through existing legal channels. The Babbitt settlement gives that question practical significance. Blanche's refusal to provide a categorical guarantee keeps it open. Future court records will determine whether critics correctly identified a pattern of political favoritism or mistook ordinary litigation discretion for something more sinister. And that is the standard worth carrying beyond this particular fight. Do not let one side turn uncertainty into certainty. Do not let the other side turn a technically accurate sentence into a broader conclusion it does not actually prove. The government has enormous power when it prosecutes people. It also has enormous power when it decides not to fight them. Both decisions deserve scrutiny. Another political clip. Court filing or official explanation will soon ask you to reach a conclusion before you have the missing context. Without a method, someone else gets to choose the frame while you inherit the credibility risk. Don't Get Played gives you a practical system for finding that missing context before you share the conclusion across clips, polls, court filings, statistics, official statements, and synthetic media. The complete digital ebook is only $9 as a one-time payment. Open the description and click the first link now. The same link is in the first pinned comment. Political reaction is easy. A conclusion you can defend requires evidence.